All right, we'll go ahead and get started. Hello, everyone, and welcome to our webinar, The Newsletter Goes Live. My name is Miranda Ward, one of your client relation directors here with Davis-Stirling. We are thrilled to see so many of you today. We have a lot of information to cover, so we're going to get started. Before we begin, this meeting is being recorded. If you require closed captioning, please request it at the bottom of the screen. This video will be available on our YouTube channel after the webinar is processed. The link will be posted in the chat for you guys, so that way you guys have direct access. We will be taking questions via the Q&A function to be discussed at the end of the program. If we do not get to your questions, please check the newsletter. Also, remember some questions may be answered as the presentation progresses, and if they are too specific of questions, they will not be addressed. You guys need to reach out to legal counsel. Now on to the presentation. Please welcome Adrian Adams and Lori Poole.
Thank you very much, Melissa.
Thanks, Miranda. So today's webinar is a little bit different than the ones we've done in the past. And this is one I'm going to admit I had to talk Adrian into doing. He wasn't sure he wanted to do this, but we know how popular the newsletter is. And Adrian spends a lot of time to review all the questions and come up with his answers that are part substantive in nature and part humorous in nature. And so we really thought it would be fun to have the newsletter go live and do this as a Q&A format where those of you who are joining can ask questions and Adrian and I will answer them live in real time. So that's how this webinar came about. So it is a little bit different format. We will be taking your questions.
Yeah, and I recommend that you keep your questions short. If they're really long, they will probably not be answered.
We don't have that long of attention span, so please.
Well, plus
Okay.
usually if they're very long, then you guys would need to know more information. You guys would need to look at documents. There isn't a way you guys could answer them. And I will say all of the questions they'll be answering today are old submissions from people trying to get into the newsletter. So we were trying to get through those with the webinar.
Right, some of those. Yeah, so go ahead. What's the first question?
All right, we're going to start off with board duties, and this one's for Lori. Does the board have to disclose information such as the name of the company and their business license information to the homeowners about the company that the HOA hired to do the painting of the units? Ours is refusing to give any information about the company they hired to paint our units.
Well, so not specifically do they have to give that information, but the Davis-Stirling Act under Section 5200, it includes a list of documents and information that members are entitled to inspect, association records that members are entitled to inspect. And one of the items on that list are the contracts that have been executed by the association. So if there is an executed contract and it has the contractor's name and license number, then as a member, you're entitled to ask for a copy of the executed contracts.
Right, there really is no reason to withhold the information. Unless it's a problem owner who wants to harass the contractor, I can understand there might be some reluctance, but basically the information is public information.
Yeah.
Okay. So next question.
All right, this one's for Adrian. Is it against the rules to not have a direct way to speak to my HOA board of directors?
Okay, well, everyone does have a direct way to speak to them, and that's called the open session during the board meetings. And so they can speak directly to the board. They can also, submit questions or issues to management, which gets passed on to the board. So there is a way to speak to them.
And remember,
this one is
honey gets you more than vinegar. So be nice when you address your
board. Oh, yeah. Okay, the next.
All right. I am a vice president of my condo's HOA board, and we are looking to change management companies. My questions are, do we need to hire an attorney to help us change companies? Do we need to have a town hall type meeting with all the owners to get a vote on whether or not they want a new management company? And can the board make the decision without involving the HOA, which I believe they mean the members?
So generally, and this is a general answer, there there may be something more specific in your governing documents, but unless there's something in the governing documents that requires the board to get a vote of the membership when changing management companies, they typically don't need to get a vote of the membership. However, it's always good if it's going to be a political issue or maybe a controversial issue. It's always good to educate the membership as to what the board's plans are, why it's looking to change management companies. So perhaps having a town hall meeting where the board can explain why they're engaging in that process could be a good idea. So, and as far as an attorney, you don't necessarily need an attorney to hire a management company, but we do always recommend, not just for management contracts, but any contract that the association is going to enter into, that you have your legal counsel review it before you sign it.
Right. Well, and also review the one, because if you're going to terminate management, you want to make sure that there's a provision that allows you to do that, that you're not going to be violating the contract and getting into a wrangle with the existing management company.
Yeah.
So that's why you would have, at least have it reviewed to make sure it's okay to go ahead and terminate the management company.
Yes. And make sure too, because there are typically procedures in the existing contract about how notice of termination needs to be handled, whether it's certified mail and who it needs to go to. So make sure you comply with those provisions as well.
Okay.
Checking to see if we're getting any live questions. All right, we're moving on to ethics now. This one's for Adrian. Can a discount in dues or other non-salary incentives be provided to get owners to serve on the HOA board? Like $100 off dues every month, or we are desperate to incentivize people to serve on the board as we don't have a management company and only 20 units.
Right. Yeah,
I'm
this
not
comes
sure
up from time
$100
to
would be
time.
enough. Let me just say, I don't know that $100 would be enough, but
Yeah, per month. Okay, there's legally, I suppose they could, but the problem is that you lose the status as volunteers and you lose all the protections that are given to volunteer directors. And so we recommend against any kind of payments to directors because then you become a professional paid director and you're held to a higher standard. So you lose a lot of those protections, which is why we advise against any kind of payments made to directors.
yeah, and also remember that the business judgment rule, which provides this protection against personal liability for directors on the decisions that are made, that applies to volunteer directors. So to Adrian's point, if a director is getting paid, you're going to lose that protection of personal liability for the decisions that are made if you're not a volunteer director. So
Right.
think of some other ways to incentivize
That'd be something, right?
the homeowners. How about taking an interest in your community and protecting the future of your HOA?
I know some get free catered meals for before their board meetings.
Yeah.
So sometimes that's an incentive, and that's okay. Okay.
All right, the next one is for Lori. Must a board member being considered for discipline by the executive committee be recused from voting for themselves? They would
So
obviously vote against discipline, and because the swing vote against in our case.
Okay, so the Davis-Stirling Act does set forth specific scenarios in which both board members or a board member or a committee member could have a conflict of interest and would not be allowed to vote. And one of those listed items in the Davis-Stirling Act is where the director or committee member has a disciplinary action against them. So yes, they would have to be recused from the vote. We even say the best practice is that board member should not be present when the board is deliberating, because you want the rest of the board to be able to have a candid conversation about the proposed discipline or the allegations and all of that. So yes, that director would.
And sometimes the question comes up, can the board member at least initially defend himself or herself? And yes, they can.
Yeah.
So if there's a charge against them, they have a right to defend themselves, and then they can leave the room so the board can deliberate and vote.
Yep.
All right, moving on to our next topic. And it appears we are getting quite a bit of questions. So We'll go ahead and answer those at the end. We were going to kind of see if we could keep them with the subject matter as we're going through different topics. It doesn't appear to be that way, but I'm happy all of you are submitting your questions. So just to let you, Adrian and Lori, know. All right, we're
Okay.
moving on to rules enforcement. Our BOD recently imposed a new rule restricting residents from inviting guests or family members to play pickleball on our property. However, we allow residents to invite guests and family members to use our pool, wood shop, gym, etc. This does not seem fair to a specific group. I have served on the board in the past, and I'm concerned that we have overreached.
Well, I like this question because of the pickleball nature of it. So it's a hot topic. Remember that under California case law, all rules need to be reasonable. And the test of a reasonable rule is the same test for recorded CCNR restrictions. And one of the things is it arbitrary? So that's what I would look at is there a reason why pickleball players aren't allowed, people can't bring in guests to play pickleball where they can bring in guests to engage in these other activities? And unless there's a good reason to keep out those pickleball players, I think you're going to find that it may be an arbitrary rule. But if it's related to noise or something like that,
Or over usage so that
or
other members don't have a chance
yeah,
to use them.
there
So there
could
may
be,
be a sound reason.
yeah, there may be a sound reason which would then make it not arbitrary and
Right.
reasonable, but that's how we would have to look at it.
All right, this next one is for Adrian. I wanted to rent our clubhouse for a couple hours for a group of ladies, all who live at our complex, but my HOA says I have to sign a waiver taking responsibility basically for their health and well-being. Since they all live here, I feel I should not have to take that on. They are owners and already entitled to use the area. It's also not in the CCNRs. I don't mind paying the deposit, also not in the CCNRs, and signing for liability and cleanliness repair of the property clubhouse. But to be responsible for a bunch of women who are already entitled to use the facility seems ridiculous to me. Can they really ask me to take on the liability or refuse me the use?
I agree it is excessive. The association has insurance that deals with that if someone is injured on the property. And to require one owner to basically indemnify the association for usage by other owners just seems excessive to me.
Yeah, the only thought I had about this one was if it's an exclusive use, like if they're reserving the clubhouse so that to the exclusion of the rest of the members for that period of time, there could be a reason that could give more of a reason why they're looking for indemnification if there was a
Yeah,
claim.
but even then, I don't agree with it. I think it's
Yeah,
excessive,
it seems overreaching
right?
for sure.
You
So
know, charging to reserve it, fine, you know, and a deposit to make sure the place is cleaned up and there's no damage, that's okay. You know, but to say that you're gonna indemnify the association, you know, for the well-being of other owners,
yeah,
I,
but that's if the guests are limited to being other owners or residents. Certainly, if you're inviting third parties in, then there's a basis to ask for indemnification and waivers.
okay,
Wonderful. All right. Our next topic is meetings and minutes. This one is for Lori. Are all board members required to attend a violation hearing?
The answer is no. It's like any board meeting, you just need a quorum of the board. A quorum is going to be a majority of the board. Some associations too delegate the hearing process to a committee that
right,
might listen, hold the hearings and make recommendations to the board. So the answer is no. You just need, if it's the board that's doing the hearings and not a separate committee, you need a quorum of the board.
right.
All right, next up is for Adrian. Can a board open its monthly meetings to all residents of the community, meaning tenants and owners?
Yes, and it's common that they do that, you know, and there's not a problem associated with it unless a tenant is disruptive in some way. But otherwise, it's probably good to get their input if they see things that need to be addressed, or for them to hear what's going on and be a part of the community. So I don't have a problem with that.
Definitely help with the overall camaraderie.
Right.
Yeah, I
All
mean,
right, moving on.
my only caveat would be is if, by inviting the non-members, I would make it clear they don't get to address the board in open session. You don't want the meetings to drag on if you have double the attendance. So that would be something to think about.
Yeah, and I don't even have a problem with them addressing the board in open sessions. They may bring to the board's attention something that's important.
Yeah,
know,
I
but,
just am
but
looking at the board meetings dragging on with
right,
tenants taking up the time and not owners.
right. And the boards get to manage their own meetings.
Yes.
And so they can say, we're going to let only owners address the board, or they can exclude tenants from attending the meeting or non-owners. But the problem is sometimes you have spouses that are not owners. And so then you'd be excluding them as well, which could be a problem. Okay.
Can be. All right, next up is operations. This one is for Lori. My HOA will not let me see the legal opinions they have asked the HOA attorney for. Am I entitled to see or get a copy of these?
No.
No.
If you're not on the board, then
Right.
you're not entitled to it. The communications between us as legal counsel and the board are subject to the attorney-client privilege. The client is the association, which is operated through the board of directors. So it is
Right.
entirely appropriate for the board to refuse to give you the lawyer's legal opinions.
All right, next up is for Adrian. Does the board have the right to hire security on the property without a vote of the membership?
Yes, they do. So the board is the one that's looking at security issues on the property, and if they feel it's appropriate to bring in security, that's their choice. So it's just going to be a matter of budgetary, can they afford it?
Yeah, it's similar to the question about the management company, changing the management company.
Right.
It's typically a board decision and it does not involve a vote of the membership.
Right.
And membership, all you have to do is step up and get on those boards to know more about all of this.
Right.
Yeah, so
All
for the
right,
one
next
who
up.
wants to see the legal opinions, get on the board.
Yeah.
Right.
All right, next up is elections, acclamations, vacancies, term limits, election of officers, and qualifications and voting. We put this all into one because we've done quite a bit on elections, but apparently we do still have, as always, questions that come in. So this one's for Lori. Can a director who has sold his house and is no longer an HOA member serve out his term on the board? Our bylaws say the affairs of the association shall not be managed by a board of directors who shall be members in good standing.
I think it
Each
shall
director
be,
shall serve,
yeah. Anyway, go
Right.
ahead.
who shall be members in good standing. Each director shall serve from the date appointed or elected until his successor is elected.
Well, until a couple years ago, the answer to this question was yes, that the person who was
You
a member
could.
at the time they were elected could continue to serve out their term even if they no longer were a member. But the legislature changed the Davis-Stirling Act within the last few years to specifically require that members of the board be members of the association. They have to own property in the
Right.
association. And that if they no longer own property, they are no longer qualified to serve on the board. So
Right.
the answer today is no.
They have to step down.
They have to step down, or they're deemed to be stepped down. Even if they don't step down, they're
Right.
just not a board member anymore, and there is a vacant position.
They don't get to push back, in other words. All right, next one is Adrian. If our HOA board is supposed to have 5 board members and only one person is listed as a candidate, is it legal to have that person be voted in by acclamation and then he or she will appoint 4 new board members? I thought acclamation required the number of candidates being equal to the number of open seats.
No, less than or equal to. So if you've got more candidates than there are seats, then it's an election that has to be carried out. But you can do acclamation if it's the same or less. So if you've got 5 open seats and only one person running, okay, that's a problem. And that person, yes, can be elected, but the only thing that they can do is to appoint other individuals to the board until they hit quorum. And then they can conduct business. And so if it's a 5-member board, they have to have at least 3 of them, 3 seats filled in order to conduct any business other than appointing people to the board.
Yeah, and keep in mind too that there are very detailed procedures in Civil Code Section 5103 about the acclamation process. So you have to have complied with those procedures in order to be able to take advantage of the acclamation process.
All right, next one is for Lori. If board members have been unanimously recalled, why would it be allowed for them to run for re-election again? It seems to me that if the community didn't want those members, that should be the end of it.
Yeah, and again, so a few prior to 2020, you may have been able to write your election rules to limit the time period in which somebody who had been recalled from the board was able to rerun for another term. But because of the changes that happened to the Davis-Stirling Act in 2020, boards are very limited in disqualifying members from running for the board, and there is no disqualification currently for a board member who was the subject of a recent recall. So
Right.
any directors who are currently the subject of a recall can absolutely put their name in candidacy for the election of directors should that recall be successful.
Right.
So.
The only requirement of Davis-Stirling is that they be an owner.
Yep.
So other
There
than
may
that,
be other qualifications that your board has adopted through the election rules, but
as long as they line up with the Davis-Stirling requirements,
right.
they can have them. And if the candidate meets those qualifications, they can run.
Yep.
All right, the next question is for Adrian. Can you clarify for me what the benefit is to electing HOA board directors to the board at the annual meeting with selection of office for each at a board-only meeting later, as opposed to the association membership electing officers to a specific position at the annual meeting?
Okay, membership cannot elect officers. It's the board that selects their own officers. What the membership does is they elect directors to the board. The board then selects their own officers, and they can do it at the annual meeting, or they can do it at a later meeting. But it would be an open board meeting, not a closed one.
Yeah, and if you think about it, so the membership are electing the people to serve on the board, but the directors who are then elected get to choose who they want to serve those officer positions. So they may not they may not be happy. There may be some of the directors that may not be happy with who the membership elected. So their opportunity then is to decide who holds those officer positions. And keep in mind too that typically the officer positions are for 1 year. So if you have terms of directors that are longer, 2-year term, the officer position may change.
Right, you can change at the next annual meeting
Yeah.
or at any point in between.
Yep.
And from time to time, I do see where the question comes up, can the person with the most votes be president? And the answer is no. That's up to the board itself to decide who's going to be president, secretary, and treasurer. Those are the 3 offices required under the corporation's code.
All right, next up we have governing documents. This one's over to you, Lori. A past HOA president who is also a lawyer, but not an HOA lawyer, attended a recent open board meeting and stated to our board that our HOA's protective covenants are not the same as CC&Rs. And since our HOA was incorporated before the Davis-Stirling Act, Davis-Stirling rules do not apply to us. We are a neighborhood of single-family, one-story homes with no common areas, with architectural design controls and a few other rules to assure their neighborhood is somewhat upscale. We were incorporated in 1968.
Okay, well, not to contradict your past HOA president, who is a lawyer, that the date of incorporation and the date that the protective covenants were recorded with the county recorder's office is not determinative of whether your community is a common interest development that is subject to the Davis-Stirling Act. There are different requirements for CC&Rs that were recorded after January of 1986 that have to have certain information, but there's actually a provision in the Davis-Stirling Act that says, you know, for declarations for CCNRs recorded after January 1, 1986, that they have to contain certain information. So by implication, any recorded CCNRs before that date don't necessarily have to have the same information. The analysis of whether or not a community is a common interest development that is subject to the Davis-Stirling Act can be quite involved. We do a lot of those analysis for clients. It may be that your community is not a common interest development and not subject to the Davis-Stirling Act, but it's not because of the incorporation date. We're going to look at, do you have common area? Do you have lien rights? Do you have the right to lien for assessments? Those are some of the things that we look at in determining whether or not a community is a common interest development subject to the Davis-Stirling Act.
Yeah, in the Davis-Stirling Act, as Lori pointed out, went into effect January 1, 1986, but we represent clients. We have associations that were incorporated in the 1920s and 30s, and they are subject to the Davis-Stirling Act.
Yeah. So it can be an interesting analysis, sometimes not with a clear answer, but we do those a lot for clients.
Right.
All right, next up is management, and this one's over to you, Adrian. A group of us are recalling the board. We asked the manager to review the language of the petition to see if it met the requirements of the bylaws. The manager declined to review the petition. What is your opinion?
The manager was correct in declining that. They're not a lawyer. They shouldn't be put in that position where they're trying to decide whether a petition is correct or incorrect. In fact, I just reviewed a petition earlier this week that was invalid because it didn't have signature lines. They collected signatures. Well, they didn't collect signatures. They collected names. They put names and addresses on the petition, but no signatures. So it was an invalid petition. But that's something for legal counsel to review on behalf of the association, not for a manager.
I agree.
All right, next up is notice and delivery. This one's for you, Lori. We are a PUD pursuant to Civil Code Section 4041. Each year, we have requested our homeowners to provide us with the current contact information, especially needed should there be any neighborhood-wide disasters, i.e. earthquake or fire. If residences are rented, being able to contact the occupant is very important. Unfortunately, many homeowners do not respond to this request for information. Under Civil Code, can an HOA demand this updated information? And if so, what recourse of action can be taken if the homeowner does not respond?
Yeah, I thought this was an interesting question. So 4041 says that, says the association has to solicit the information and that the owners have to provide it, but we all know that the owners don't. There were a couple things on this I wanted to touch on. One was, while I can understand wanting to have the contact information in case of an emergency, I also wouldn't want to put the board in a position of taking on a duty of having to notify occupants in the event of an emergency. What if it couldn't? You know, you don't want to take on a duty that the board may not be able to fulfill. The other thing is as far as some kind of indicating it's some kind of violation if the owner doesn't submit the information and subject to maybe now it's $100 fine. I thought that was an interesting idea, but I don't know that that would be deemed reasonable because 4041 does give the association a backup and says that if the owner, doesn't provide the information, then this is how notices are to be provided. So it's built into the law, assuming that the owners aren't going to respond and the association has, at least from a legal standpoint, what it needs to do to comply with notice requirements. So I think it might be problematic to actually fine the owners for not submitting.
Right. I wouldn't recommend it.
Yeah.
Especially now. All right, next up is rental restrictions. Our CCNR state of Adrian, this one's for you. No hotel or transient type rentals. Is this sufficient to restrict short-term rentals?
Yes, it is. And then by statute is what anything less than 30 days can be prohibited. And so the board is allowed to interpret their CCNRs, and transient can be interpreted to mean anything less than 30 days.
I still think it would be better to have the CCNR, or the rules to have a specific minimum lease period. But in the absence of that, I agree with Adrian, that language has consistently been interpreted to prohibit rental less than.
Yeah, and I agree. It should be put in the rules so that you've got it in writing somewhere, so it's not deemed arbitrary.
Yeah.
In a perfect world, right? All right, next up we have leaks, and Lori, this one's for you. We have a new owner at our 28-unit condominium. Their unit was bought at auction, sight unseen. After purchase, the new owner and the HOA found out the unit had extensive water damage from leaks in the roof. Is the new owner responsible for the repairs inside the unit, even though it was caused by the roof? Or is the HOA responsible even though they were not notified of the leak?
Yeah, so I like this question. I mean, this is one of my I love the whole water leak, water intrusion. Anybody who knows me knows I love to talk about this. So the general rule, and a lot of associations and boards and even managers don't understand this, but the general rule is that the association is never responsible for the resultant damage that occurs inside a unit due to water leaks or water intrusion that comes from outside the unit, such as the roof in this scenario, unless the association was either negligent, or sometimes the CCNRs say unless the association was grossly negligent in maintaining the item that led to the water intrusion. So we see a lot of situations where the boards think just because the roof leaked, the association is responsible for all resultant damage inside the unit. And the answer is no. Now, there may be other issues about insurance coverage under the HOA's property damage policy that may cover some of the damages here. That's a different issue. But generally, I would say, unless there was some negligence or gross negligence, the association is not responsible.
And I give you an example of that. First of all, if the association hasn't been regularly maintaining the roofs, haven't been inspecting, that could be deemed negligence and they could be liable. An example where an association would not be liable is where an association, a raccoon, peeled away the tiles to get into the attic to have her babies. And then it rained. And so the unit was damaged. The association didn't cause it, wasn't negligent, was not aware of it. And so in that case, the owner's insurance would pick up the damage and the association would repair the roof. Okay.
All right, next up, this one's for you, Adrian, and it's EV charging stations. I would like information on electric vehicles. Our association has found that residents are charging their vehicle on our dime. The garage's electricity belongs to the HOA, and as such, unfortunately, the homeowners are using our power. We are thinking of installing meters at the owner's expense. What are other HOAs doing?
Okay, well, for sure they are stealing the electricity. The association can have electrician pull out those outlets and cap them off. But then you do want to provide some means for people to charge their electric vehicles. I mean, that's the direction everything is moving. And so they can allow the owner to install a vehicle, electric vehicle charging station. We have some associations where they install the backbone on the ceilings of the parking structure so that owners then can tap into it and install the charging stations. So it just depends. And there are also incentives available through what Edison and DWP, and some of the other companies, but where you can then bring it and have a number of the units installed at a reduced expense for the association. So it's just something they need to investigate, find out what's the best way of handling it.
Yeah, and I've had clients that have aren't set up to be able to, have separate vehicle charging stations in each space. So they've come up with a calculation of reimbursing the association for the electricity that's being used in those circumstances when it is somebody plugging in to the master, electricity that's not separately metered. But I would say the best thing is if there could be a way to separately meter that electricity usage, to do that.
Right.
And it's not just electric vehicles. You deal with it with things like refrigerators, any of those items that are going to be a drain on the HOA's electricity in a situation where there is no separately metered electricity to the unit or to the garage.
All right, next up we have reserves. And Lori, this one's for you. I have a question about reserve funds. We have money allocated to replace mailboxes that are perfectly fine and do not or and not need in and not in need of replacement. Is it possible to reassign that money to another project that is currently necessary that doesn't have enough money to cover and will be assessing the shareholders to cover the total cost?
Yeah, so generally speaking, the reserve fund is what I know the reserve study is written so that there's different line items and different amount of money that is allocated to each item, but it is one fund. It is one pooled fund. So the board is allowed to use the reserve money for the items that are reserve items. So if it is that, we have X amount of money reserved for the mailboxes, but we need that money now to do something else. You're going to pull that money, but you're going to have have the reserve analyst maybe update the study to show,
Right.
what the time then is to build back the money to replace the mailboxes when they do need to be replaced. But
I
it's
agree.
one pool of money. And as long as you're using it for reserve items, it's not considered borrowing from reserves, and you can use it for different line items despite how they're broken down in the reserve study. But of course, the way they're broken down is based on the reserve analyst's careful analysis of each component and the estimate of the remaining useful life. So don't ignore it.
Right. And it may be that as a result of that, shifting of funds around within the study, that you may need to allocate more in the next budget towards reserves.
Right.
So just working with the analyst to find out what you need to do.
Yeah.
All right, next up we have finances. And Adrian, this one's for you. Can an HOA board move unexpected excess revenue at the end of the year to the reserve account in order to zero out revenue and not incur a tax liability?
Yes, and they should. But if the association were to file an 1120H, then, that's only on non-dues income. They wouldn't be paying any taxes on it to begin with, but it's always better to have it allocated into reserves. Most associations have underfunded reserves, and so it's always a good idea to build those up whenever they can.
All right, so now we're going to hop over and go to our live questions. So these were coming in as I was reading off, so bear with us, everyone. Okay, can you talk briefly about the difference between an attorney providing general counsel services versus an attorney providing case-by-case services? Our board recently discontinued an agreement for general counsel and executed an agreement for case-by-case services. This was supposedly done to reduce expenses, but I am concerned that we've reduced the quality of service by not having general counsel.
Hey, I don't know what that means because the board's going to be asking that person questions as they come up. So it's basically they're still general counsel. Uh, Unless the general counsel was charging retainer fee, an annual fee, then you can eliminate that. And then you just deal with questions as they come up, legal issues with that attorney.
I agree. Without seeing the two different contracts, it's hard for us to speculate on what that means. But I agree with Adrian. It may be that the general counsel was under some kind of annual fee that your association got certain benefits and services for that under the case by case. They're not paying the fee and they're not getting those benefits and services.
Yeah, and we have some of our clients that are basically on that, where they don't pay an annual fee and they only call us when they need to. And it's a lot of times it's when they only have maybe one or two questions that may come up a year, and they're fine. And then suddenly something comes up where they're using us heavily because there's a big issue that just came up. So, it just depends on the particular association and what their needs are.
All right. What are the steps for us to elect a new board member when the board no longer has a quorum?
So yeah, the corporations code does say that the board members, even though they're less than a quorum, they can take action to appoint somebody to fill vacant positions to then get to the quorum. So even though you don't have a quorum of the board, you are empowered under the corporations code to appoint directors so that you get to your quorum level.
And I check the bylaws. Occasionally I see where it says that if there's a vacancy on the board calls a special meeting in order to elect to fill that vacancy. I don't see that very often. It's fairly rare, but it's something you want to take a look at. The more efficient way to handle it is for the board to just appoint somebody to fill it until the next election.
All right. Is there any financial information the board can ask an owner to provide who is requesting a payment plan on like a special assessment?
I suppose they could. I mean, it's not covered in the Davis-Stirling Act, but if the board wants to verify that there is a problem that requires them to um, come up with a payment plan, I suppose they could ask for financials. It's kind of delicate.
Yeah. Yeah, I've had this question before. And asking the owner to submit their last year's tax returns. I mean, I don't know that that's going to tell the
Right.
association the full picture of their financial situation. So I think, to some extent you do need to, you do need to, give the benefit of the doubt to that homeowner who's requesting it.
Yeah, I think just sitting down, coming up with a reasonable payment plan, and they need to stick with it. Otherwise, you could take collection actions.
Yeah.
Right. Are there any repercussions to not having annual meetings?
Well, I mean, most bylaws
Required,
require that the association have annual meetings. And if you don't
right?
have annual meetings, how are you electing your directors?
Yeah,
So
and annual
most
meeting,
bylaws require an annual meeting where you elect the
right?
director. So you're going to be violating your bylaws.
Yeah, the problem comes up is when they can never meet quorum, and that happens. But you're still required to have the annual meetings,
Or attempt to have, I guess, is
right?
I think that's the difference there.
Well, and you can have an annual meeting, but you can't conduct any business if you don't have quorum. So it might be that you would just review what happened in the year behind that just occurred and what you're planning to do for the next year. And the directors would just continue to carry over until, you get resignations and then they would appoint replacements. But it's really a problem, especially in the really large associations where they just can't make quorum. And that's why we put in our bylaws that the quorum is not required for the election of directors.
Well, and remember too that the Davis-Stirling Act was amended in the last couple of years to give the association the ability to reduce the quorum for an election of directors to 20%, even if the bylaws don't authorize that. So there's procedures that have to be followed, but as long as you follow that procedure, then even if you don't meet the quorum at the first meeting, you could adjourn it and that quorum could reduce to 20%. So that may help.
But I had a large association that had the quorum drop to 15%, and they still couldn't even meet 15. Yeah, and so and I advise them to amend their bylaws, which of course is problematic if you can't even make quorum. And so what they did, they authorized us to go into court to have the court reduce the quorum to the number of ballots cast, and that's how they had their election.
But that's expensive to do every year. So maybe
Right.
telling your homeowners how much they had to spend to do that petition and why their assessments are being increased to pay for the legal fees for that petition, maybe that'll get a few more ballots in the door next time.
I bet it would. All right, this next one is general, but I will have to say we get it at least a handful of times a week. So what can you do if the HOA board is not complying with the law and statutes if you can't afford an attorney?
Yeah, it happens. And that's where you have to, run for the board, get yourself on the board.
Yep.
And, pull together others that like-minded.
Yep.
And once you get control of the board, then you can make sure that procedures are put in place that you're following the Davis-Stirling Act.
Yep. And document in writing, make sure you put it in writing why you believe the association, the board is not complying with the law, and submit that as well. But I think Adrian's idea of running for the board and getting on the board and making sure that you're complying is it's going to be your best bet.
Right.
Yep, I believe on our link that we have on the website, the last resort is sometimes people just have to move.
Well,
Unfortunately.
and keep in mind
all right,
too, that
next
as
up.
a home, sorry, Miranda, keep in mind too, that as a homeowner, you have the right to request an internal dispute resolution meeting with the board. So maybe ask the board to engage in an internal dispute resolution meeting where you could express again how you believe that they are not complying with the law and the Davis-Stirling Act, and see what they say.
Yeah, because sometimes you just have bad boards and and they're not responsive and they don't care. And that's where you have to just pull together other owners and make sure that you could get elected to the board, get control of the board.
Yeah.
And even if you don't get control of the board, a person on the board can push, that to get compliance. And sometimes they can be successful in doing that, to be the gadfly.
All right, so this is more of a clarifying question on something we touched on earlier. Can association members also request the contract of their property management?
Yes,
Yes.
if it's been signed.
Right.
The
So
executed
an
contract.
executed contract. Right.
If our corporation is being sued, does the board have to share the information on the person who is doing the suing?
They don't have to, but they can. It's a public record. So they can, and there are also disclosure requirements for the year-end financials dealing with litigation. And I recommend that they notify the membership, yes, we've been sued, and here's who's suing us, and here's why.
And here's the case number in the case you want to look it up,
Right.
So, yeah, and a lot of times too, lenders are going to ask if the association's in active litigation and they want some information.
Right.
So a lot of times the attorneys who are handling that litigation will prepare what we call a litigation disclosure letter. It usually doesn't have a whole lot of information, but it does have the names of the parties, the case number, and maybe a brief description of what the dispute is about.
Yeah, and then I just dealt with an association where an owner, two board members sued the association that there wasn't any merit to it, and they were unhappy that it was disclosed to the membership that they sued the association. They eventually dismissed the action. But yes, the association has the right to disclose.
Well,
Go
and
ahead.
once it's filed, it's a public record.
Right,
So,
public record.
yeah. So if you don't want the owners in your community to know that you've sued the association, don't sue the association.
Don't sue the association, right?
Can we incorporate newly adopted rules such as from AB 130 into the annual budget instead of sending a separate mailing to the membership?
Well, remember, notice of new rule changes only needs to be done by general notice. So there are different ways to comply with the general notice requirement. It could be posting in a prominent location in the common area. It could be posting on the website if your annual policy statement has indicated that that's where you're posting general notices. So technically, notices of rule changes only have to be done by general notice. Inclusion in a billing statement is another one. I don't believe that general notice actually does include inclusion into the annual disclosure. I would need to double check the statute on that, but I don't think that's
Right. And there may be something dealing with this recent change with AB 130 that may require specific notice, individual notice. You'd have to take another look at that.
Yeah, I don't think it does, because it doesn't really address changing it doesn't really talk about changing enforcement policies. So you'd be under the same rule adoption policy that's in the, or procedures that's in the Davis-Stirling Act.
Yeah, and
So,
dealing with that AB 130, if their current policy is to charge a $500 fine and they have to reduce it to 100, I don't think that has to go out for a 28-day review. They can just make the change because it's required by statute.
yeah, I agree with you. I do think if they're going to adopt a fine schedule to address violations that may adversely impact the health or safety of the common area or another member's property,
Right,
that would have to go out for a 28-day review.
right,
So, but remember, rule change notice is technically only by general notice. We do recommend, though, to our clients that they either mail or do an e-blast or something of a proposed rule change once they've met the general notice requirement.
Right. So we're skipping to excuse me, AB 130. Does the new fine law apply to violations that occurred before 7/1/2025?
Well, technically, the effective date is 6/30/2025, so keep that in mind. Yeah, our position is no. If you imposed a fine prior to June 30th, 2025, that's higher.
right,
That's fine. I think the issue is where you impose the fine maybe that last week of June and you haven't given notice or hadn't given notice. We're now beyond the 15 days,
right.
or 14 days. Now it's 14 days.
Now it's 14 days.
But I think that's a tougher call as far as I think you technically probably still could collect the higher amount. I just don't know that it's worth it.
Right.
All right. With water leaks, if a previous HOA board has covered the cost of interior damage from an HOA leak, does this set a precedent where a future board cannot cover the damage?
In my opinion, no. First of all, how are you going to pay for it? How's an association going to continue to pay for resultant damage inside the units for each of the homeowners? What if somebody has, and Adrian has the example of somebody that had, what was it, like 14 karat gold leaf wallpaper
Right,
or something that was damaged?
right.
You don't, the association doesn't, you're not reserving for these types of expenditures. So,
It's a
I
case by case analysis too.
yeah, yeah, but I would not take the fact that the association has maybe in error paid reimbursed owners or paid for that damage in the past where there was, where they didn't have to. I wouldn't necessarily take that as we're now stuck to that going forward. But that's a very
Right.
general answer to probably a much more specific question that would need closer view and analysis by legal counsel or general counsel or case by case counsel.
All right, we're going to keep on the AB 130 for a minute. With regard to the new law regarding fines, are you prohibited from escalation of fines for first, second, and third violations? For example, it has to be $100 for the first, second, etc., and cannot
No,
increase beyond the $100 for each offense.
right. First one could be $25, second one could be $50, and the third one $100, but you can't go beyond the $100.
I agree.
All right.
But I don't recommend a
Okay.
fine schedule like that. I would just start with $100.
Right, right.
Who can request an audit on an HOA account?
Well, a board can, but individual owners cannot. I mean, they can't, and well, they can request it, but the board is the one that's going to make the decision as to whether there's going to be an audit or not. And if we're talking about general audit of the finances, the association's
Yeah.
finances, all that's required by statute is a review unless the bylaws call for an audit.
Switching gears a bit, if the HOA loses its lawsuit, which claimed damages to community property, does the board then have a responsibility to repair the claimed damages on its own nickel?
Oh, well, as individual directors, no. The association, if they're required to make the repairs, the association would make those repairs. Yeah, I'm not sure. We've got
Yeah,
the
I'm not sure
picture
what
there.
the actual question is, but
Yeah,
if there is a court
I-
telling the association they have to make the repairs, then yes,
then they
the
have to make the
association
repairs,
should make the repairs.
right?
All right. Would there be liability to an HOA manager if the HOA board is not following the Davis-Stirling Act?
No, the board is the one obligated to follow the act. Not, well, and the managers are gonna follow it too. I mean, if the manager is doing something improper, the manager could be liable for it, but if it's the board that's not following, that's the board's issue.
Like I said, I didn't read through these first. I feel like I just have to read this one and have you guys answer it out loud. Can the property management company charge the association for legal counsel fees without board approval for each consultation?
Ooh, if it's in their contract that they can do it, then yes. If it's not, then no.
And a lot of contracts do authorize the management company to spend up to a certain amount of money without board approval. So that is a matter of contract between the association and the management company. So
Right.
if you don't want your management company to incur those kinds of expenses, you need to make sure the contract says that.
Right.
We have about 2 minutes left, guys. Do you want me to keep rolling through these
Yeah,
questions? We
let's
have
go through some
plenty.
more.
Yeah, but Miranda,
right.
I actually have a question for you that people might want to know. Since you are the
Okay.
gatekeeper of the newsletter questions, how many do we get on a weekly or monthly basis, would you estimate?
I would say we at least get about 8 to 10 a day.
Wow.
Those have been my numbers. And when Adrian puts out the newsletter, that is up to about 30 to 40, depending on the content of it.
Yeah, it spikes the number of questions. Right.
Mhm, mhm.
So eight
So we
to
get
10 a day. For those of you who have submitted questions and they haven't been answered
That's
through the
why.
newsletter, that's why. Also, ones that are very specific are not going to get answered.
Right. And if they're really long, they're
Again,
writing me a book, they're not going to get answered.
yeah, Adrian and I have short attention spans. So
Right.
the longer the email, the less likely it's going to get included in the newsletter.
Right.
short and simple is best.
In
Right.
general.
All right. Let's see. If the association membership passed an amendment to the CCNRs, but it was not recorded at the county, is it valid?
Well, it's not valid until it's recorded.
Yeah.
It has to be recorded to be effective.
Yeah.
So can they do a late recording? Yes, they
Yes.
can.
Yes.
Let's see.
Must be a
A
long
really
one.
good,
Find a
a
good one,
really good
guys.
one to
Sorry
end
about
it,
that.
Miranda. We need
I
a
know,
really good
right?
one
I'm
to
trying
end
to
it. Bring it home, Miranda. Bring it home.
hopefully I pick a good one. All right, I'm just gonna pick this one. Okay. We have okay, we are a master association. We have a sub-association board that is not complying with the bylaws and the CCNRs of the master. We've tried to have meetings with them and they refused. What action can the master association take to get them to comply?
This sounds very
Well,
similar to a question that one of my clients has been asking me.
well, they're now maxed out at $100 to fine them. But it's going to end up if they're not complying and they have to get compliance, they may have to take legal action. So it'd start with a lawyer letter to them threatening legal action, but requesting ADR in order to resolve whatever the issue is.
Well, but it also depends too on the relationship between the master and the sub association. And that's going to be largely dependent on what the documents say. So You know, is
Right.
there an actual, does the master have jurisdiction to enforce it against the sub? So, you know, that's a pretty specific question that's going to really need legal counsel to look at the specifics and provide guidance.
Right.
Do we want to go ahead and stop there or keep going?
Okay, one last question, then we're done.
All right. We'll see. Now I should have picked another one. We're just gonna go eeny, meeny, miny, mo on this. Hopefully it's a good one. Oh, can you amend your CCNRs and bylaws without having to rewrite them?
You can.
Sure. Yeah.
You can do line item amendments. At
Right.
some point, if you're doing too many line item amendments, it's better to do a restatement. It might be more less confusing.
So the difference being restatement and amendment are two different things.
Right. Yeah, and I've seen CCNRs that have 5, 6 amendments. The problem with it is that sometimes those amendments get lost in the shuffle. And that becomes confusing. And so it may be time to restate the documents. And also if they're old, they may be difficult. They're out of line with the Davis-Stirling Act, and you just need a clean set. And are they difficult to get past? They always are, but it's doable. It can be done.
Yeah, it's very doable. And technically a restatement is still an it is considered an amendment. So under provisions of the Davis-Stirling Act concerning the petition process, even though it refers to amendments, not restatements, it is the same thing. But just in practice and practicality, there is a difference between line item amendments and a complete restatement as far as what the document is. So.
Yeah, and we do recommend that on older documents, they do restate them. And especially the bylaws. Bylaws are the ones, because of all of the changes in the Davis-Stirling Act, that tend to be more out of line with things, especially with election issues, than anything else.
And I actually think the CCNRs, because the CCNRs, if you haven't restated your original developer written CCNRs from like the 80s, you know, it still has a lot of obsolete language concerning the declarant. It very likely does not specifically as you want it to spell out the maintenance, repair, and replacement obligations of the association, which you can only do in the CCNRs. You cannot do that in any other document. So there really are a lot of reasons to restate both the CCNRs and the bylaws. And old is, you know, how old is old? You know, I mean, it's kind of sad to me, but even now, documents that were written in the early 90s are old. Documents that were written in the 2000s are old. The early 2000s are old.
And you can have stuff that's more recent, but if it's really badly drafted, it may need to be restated.
Yeah, and there's been so many changes to the Davis-Stirling Act, even in the last 20 years, the last 15 years. So it doesn't take that long with the way the legislature is going to make the document.
Oh, man. Yeah, the legislature's out of control. Okay, well, I think that's it. Let's thank everyone and wrap it up.
Thank you.
Well, I want to thank everyone, our attendees, and obviously our wonderful attorneys, our speakers. I did want to let everyone know to keep those questions coming in for the newsletter. And don't forget, you guys can ask questions. The website, I won't give you legal advice, but I'll be able to give you links from the website that should help navigate the question. So please keep those coming.
All right. Thanks, everyone.
Thank you.
See you guys next time.